Welcome to EU Privacy for All, Session 56 on GDPR, Articles 77, 78 and 79 on the right to lodge a complaint and to judicial remedy. Articles 77, 78 and 79 tackle the right to lodge a complaint with the supervisory authority, the right to an effective judicial remedy against a supervisory authority, and the right to an effective judicial remedy against a controller or a processor. Article 77 on the right to lodge a complaint with the supervisory authority lays down that, without prejudice to any other administrative or judicial remedy, a right to lodge a complaint with the supervisory authority is laid down in the regulation and in particular in the member state of his or her habitual residence, place of work, or place of the alleged infringement. The supervisory authority with which the complaint has been lodged shall inform the complainant. Article 78 on the right to an effective judicial remedy against a supervisory authority sets forth that, without prejudice to any other administrative or non-judicial remedy, each natural person or legal person has the right to an effective judicial remedy against a legally binding decision of a supervisory authority concerning them. Without prejudice to any other administrative or non-judicial remedy, this right to an effective judicial remedy exists where the supervisory authority competent in accordance with the consistency mechanism does not handle a complaint or does not inform the data subject within 3 months on the progress or outcome of the complaint. Those proceedings against a supervisory authority shall be brought before the courts of the member states where the supervisory authority is established. Where proceedings are brought against a decision of a supervisory authority, which was preceded by an opinion of the European Data Protection Board in the consistency mechanism, the supervisory authority challenged shall forward that opinion or decision to the court. Article 79 on the right to an effective judicial remedy against a controller or a processor entails that, without prejudice to any available administrative or non-judicial remedy, each data subject has the right to an effective judicial remedy where he or she considers that his or her right under the GDPR has been infringed as a result of the processing of personal data concerning him or her by the controller or the processor. Proceedings against a controller or a processor shall be brought before the courts of the member state where the controller or processor has an establishment, but alternatively, such proceedings may be brought before the courts of the member state where the data subject has his or her habitual residence, unless the controller or processor is a public authority. A key provision in the GDPR is Recital 141. It stresses that the right to lodge a complaint, in particular in the member state of the habitual residence of the data subject, and the right to an effective judicial remedy, shall be brought in line with Article 47 of the Charter. The investigation following a complaint should be carried out subject to judicial review, and the supervisory authority has an obligation to inform the data subject of the progress and the outcome of the complaint within a reasonable period. If the case requires further investigation or coordination with another supervisory authority, an intermediate information shall be given to the data subject, and each supervisory authority should take measures such as providing a complaint submission form. The directive lays down in Article 28 on supervisory authorities that decisions by the supervisory authority which give rise to complaints may be appealed against through courts. Each supervisory authority shall hear claims. The person concerned shall be informed of the outcome of the claim, and the person shall at any rate be informed that a check has taken place. What should accountable data controllers and processors get prepared for? Data subjects have the right to lodge a complaint with a supervisory authority without prejudice to any other administrative or judicial remedy. This right can be exercised in the member state of the data subject's habitual residence, place of work, or of the place of the alleged infringement. Each complainant will be advised on the complaint by the supervisory authority to which the complaint has been lodged. Data subjects also have the right to an effective judicial remedy against a legally binding data protection authority's decisions, without prejudice to any other administrative or non-judicial remedy. This right also applies when a supervisory authority does not deal with a complaint or does not inform the data subject within 3 months about the progress or the outcome of the complaint. The complaint will be brought before the courts of the member state of the supervisory authority. It could alternatively be brought before the court where the data subject has habitual residence, unless it tackles an issue regarding a public body. Data subjects finally have a right to an effective judicial remedy against a controller or processor infringing the regulation. The complaint will be brought before courts of the member state where the controller or processor has an establishment, or if the controller or processor is a private entity, where the data subject has his or her habitual residence. The question triggered now is whether there will be an harmonized approach on complaints received by supervisory authorities and by the courts.